Thank you. Good evening. My name is Joe England. I'm a barrister here at Quadrant Chambers. And the title of my QBiT talk is What is Dishonest Assistance? Now, the clue is in the name, largely, because the three elements of this cause of action are not only assistance and dishonesty, but of course the third is that there must be an underlying breach of trust or fiduciary duty. And like a lot of related claims in this area, such as knowing receipt or other equitable proprietary claims, a lot of the key law in this area was made in the 90s with judges like Lord Neuberger and Lord Hoffman sitting at first instance and Lord Millett, and remains good law to this day. And this is especially true of dishonest assistance, where the leading case remains a 1995 House of Lords decision of Brunei Airlines versus Tan. And that established those three elements: breach of fiduciary duty or trust, dishonest assistance with that breach by the assister, and thirdly, and most difficult often, dishonesty. But I'd like to now say a few words generally about dishonest assistance and why it's quite a useful cause of action. Firstly, it's fault-based rather than receipt-based or based on restitution. It's also a personal claim, so often it's mixed with proprietary claims where you're tracing funds. But if the funds have disappeared, you can go after the individual for the sum of money, if often is the case, but proprietary funds are untraceable or disappeared. It's also a very useful way of avoiding the corporate veil. You may often have a defendant, a company, who's impecunious, and the real villains of the piece are in fact the directors behind the company, and ordinarily in a debt claim you wouldn't be able to pierce the corporate veil. However, with dishonest assistance, it's very useful because you can seek profits made by the assister. You can also seek damages that arise from the breach of trust rather than necessarily the dishonest assistance, so you're covered in that sense for the primary wrongdoing. It's also not necessary to prove, often there is one, a combination or agreement between the primary wrongdoer and the person assisting. Also, technically, the primary wrongdoer doesn't have to be dishonest or have committed a breach of trust or fiduciary duty dishonestly in order for you then to establish dishonest assistance against the assister. And then, of course, there could be a situation where the primary wrongdoer is found not to be liable. There are, for example, defences under the Trustees Act 1925, but you can still, in those circumstances, found dishonest assistance against the assister. What is assistance or procurement of the breach of fiduciary duty or trust? Well, unsurprisingly, it's a question of fact. It can happen even if the breach would have occurred without your assistance, but there must be some causative element. An interesting case in this area, again from the 90s, there's a case called Brinks Limited versus Abu Salah, number 3. This is when a wife accompanied her husband, who was a money launderer, on various holidays to exotic destinations or trips, and it was said against her that she, by attending these trips, gave him an air of legitimacy and therefore facilitated the fraud. The court found not so. They found her intention on going on these trips was essentially to have a free holiday rather than to actively participate in the fraud, so she was found not liable. There are many examples of what can constitute assistance. It can often be moving money from a trust account to a non-trust account, sending payments to other companies or companies related to you. Or for personal use, often you find people treat the trust funds as if they are their own. It could be authorising payments to other companies and people. It could be even less obviously, for example, drafting an agreement that's part of a sham to facilitate a fraud. It could be submitting or drafting false invoices. Why do we also say procure as well as assist with the dishonest assistance? Well, technically, if a director causes a company to act in a certain way, that could be procuring rather than assisting. Also, another good example from the case law is where a parent induced trustees to make a distribution of trust property to their illegitimate children as opposed to the legitimate children, and did so by forging birth and marriage certificates. So that is actually technically procurement rather than assisting with dishonest assistance. Now, what about the third category, the difficult one, dishonesty, which isn't present, for example, in knowing receipt? Again, the test in Brunei versus Tan has stood the test of time, despite several judicial statements since. And essentially, you're looking at somebody not acting as an honest person would in the circumstances. Often that involves looking at two things. It involves firstly looking at what the dishonest assister actually knew, rather than what they should know. So that perhaps makes it easier for the assister. But then the second part is a more objective test, and it looks at what the standards of honesty are to measure them against what the reasonable or honest person's circumstances would judge that to be, rather than the subjective values of the defendant. Because as you know, if you've ever had a case with fraudsters, they often have their own internal psychology which justifies their actions, often called doublethink by psychiatrists. And that's very common in fraudsters, to justify the fact as to what they're doing. Now, it can often, with dishonesty, involve sort of actual knowledge dishonesty. So you're in a situation where you can see that someone's moved monies from a bank account in breach of trust. But where it becomes more complicated is more implied knowledge situation. And this is where you have doubts and suspicions, but then deliberately and consciously take a decision not to question or cross-question those suspicions and allow matters to proceed. So you've got to actually take that decision. You can't just say, I thought perhaps something a bit dodgy was going on here. It's got to be tied to something specific. And it's also, you've got to take a decision, and the other side have got to prove you've taken a decision to not act on those suspicions. You also don't need to prove that the wrongdoer knew every detail of the breach of trust. For example, the specific clause, for example, that was being breached. As long as there is a general knowledge that the transaction to which he's assisting is not one in which an honest person could participate. Finally, also, it doesn't necessarily matter if the dishonest assister says, well, I didn't mean for the person to be a victim as a result of my actions. Or, for example, as I had in one case, we'll put the money back when we're in good times, but we just needed it for a particular reason at the time. So that also is not a defense to dishonesty. So one is looking, as with assistance, at all the facts and circumstances. So what would you look at as a guide if you were a judge to decide whether someone was dishonest? Well, you'd look at the nature and size of the transaction involved in the underlying breach and the assistance. You'd also look at the alternatives in the scenario that an honest person could have taken that the dishonest assister didn't. You'd also look at the degree of doubt, the consequences for the victims, but also you'd look at the attributes of the defendant, their experience, their position, their intelligence. Finally, limitation. In these types of claims, there is a 6-year limitation period from when the relevant act and of dishonest assistance took place. There's not, in contrast with some other claim under Section 21 of the Limitation Act 1980 to do with trustees. There is a limitation period for these claims. Of course, it is subject to Section 32 of the Limitation Act, which allows you to extend time, for example, for concealment of facts by the dishonest assister, or for example, when there's an action in fraud, which dishonest assistance would count as. Of course, it's got to be concealment by the dishonest assister or a fraud claim against the dishonest assister rather than the primary wrongdoer to rely on Section 32. So that, in a nutshell, is dishonest assistance.